Bridgewater Township Planning Board for Wednesday, June 25th, 2025, special meeting. Adequate notice of this meeting has been given in accordance with the Open Public Meetings Act, NJSA 10:4-6. On January 6th, 2025, proper notice was sent to the Courier News and the Star Ledger, filed with the clerk at the Township of Bridgewater, and posted on the bulletin board in the municipal building. Please be aware of the Planning Board policy for public hearings. No applications will be heard after 9:30 p.m. and no new testimony will be taken after 10 p.m. Hearing assistance is available upon request. Accommodations will be made for individuals with a disability pursuant to the Americans with Disabilities Act, or ADA, provided the individual with the disability provides 48 hours advance notice to the Planning Department Secretary before the public hearing. However, if the individual should require special equipment or services, such as a CART transcriber, 7 days advance notice, excluding weekends and holidays, may be necessary. Would everyone please rise to salute the flag? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Mr. Simone, could I have a roll call, please?
Yes. Chairman Vessio.
Here.
For the record, Mayor Minch is absent, and Mr. Pappas is absent. Councilman Kirsch.
Here.
Mr.
Here.
Magora.
Here.
Ms. Sikora is not here. Mr. Bang is absent for the record. Ms. Chartowitz is absent for the record. Mr. Chowdhury. And Mr. Atkins is also absent for the record. And we have Board Attorney Mr. Peck.
Here.
And Ms. Daniel Green, Township Affordable Housing Planner. Oh, Darlene, I'm so sorry. That's it.
I believe there's one more.
Oh, Mr. Wang, sorry about that. Glad you could make it.
Okay, we do have a quorum this evening. Okay, first order of business for this evening, I'd like to ask for a motion to appoint an acting board secretary for June 25th, 2025. Who'd like to make that motion or nominate? Who would you like to nominate? Who would you like to nominate?
Mr. Magora.
Mr. Magora, who would like to second that motion?
I'll second.
That's Councilman Kirsch. Could I have a roll call, please?
Chairman Vessio.
Yes.
Councilman Kirsch.
Yes.
Mr. Magora.
Yes.
Mr. Wang.
Yes.
And Mr. Chowdhury.
Okay, next order of business. If there are any members of the public here this evening that would like to address the board on any matters not listed on the agenda this evening, please feel free to come forward at this time. Okay, seeing none, hearing none. There are no board minutes, resolutions, or applications this evening. We are going to entertain, item number 9 on our agenda this evening is the adoption of the fourth round housing element and fair share plan of the Township's master plan. And who will be giving that presentation this evening?
Good evening, Mr. Chairman, members of the board. Darlene Green with the firm of Colliers Engineering and Design. I am the Township's affordable housing planner.
Good evening. We'd like to swear you in this evening, Ms. Green.
Do you swear or affirm that the testimony you're going to give in the course of this hearing will be the truth and nothing but the truth?
Yes, I do.
Thank you very much. You may proceed.
Thank you. Tonight I am here to present the 2025 Housing Element and Fair Share Plan, but before I talk about that, I think it's important to give a little bit of a preface. Why is the Planning Board meeting on a special night at the end of June? It seems a bit odd, and that's because this is something that we are forced to do, and I'll get to that in just one moment, but let me start at the beginning. And affordable housing in the state of New Jersey starts all the way back in 1975 when the New Jersey Supreme Court ruled that every town in the state of New Jersey has a constitutional obligation to provide a realistic development potential for affordable housing. Simply put, it does not mean that towns have to build the affordable housing. We have to put in place the zoning and/or the mechanisms to enable the construction of affordable housing. That ruling set off a litany of litigation because unfortunately it didn't tell towns how to comply with this newly mandated constitutional obligation. So it wasn't until 10 years later and a lot of court filings that the legislature realized they needed to bring calm to the chaos, and they adopted the Fair Housing Act. The Fair Housing Act created the Council on Affordable Housing. I'm sure some of you read their name in the paper. COA was their acronym. COA was tasked with promulgating the affordable housing obligations for communities, issuing regulations on how towns were to go about that process, and the framework of the regulations. And so COA was often running and started the first round of affordable housing, which ran from 1987 until 1993. They were 6-year rounds. The second round, then, towns were issued numbers, they had a chance to adopt housing plans, and the builders could build the units. The second round ran from 1993 to 1999. And at the beginning of the third round, COA said, you know what? 6 years is not quite enough time to issue those affordable housing obligations, have towns write their affordable housing plans, and then have builders actually build all this housing. Let's make it 10 years to give everyone a little bit more breathing room to accomplish all these tasks. So they changed the rounds to 10-year rounds. And COA also thought it might be a good idea to amend their rules and the way they determine the obligations. And that was not a good idea, because every rule set that COA published was challenged during the third round. And ultimately, in 2015, litigation was filed, and it went to the Supreme Court, and the Supreme Court said, COA, you have failed to do your job in administering affordable housing. So we are stripping you of your power of reviewing affordable housing compliance, and we are returning the review of affordable housing compliance to the courts, unwinding what had been done by the legislature back in 1985. For this reason, the third round was not a 10-year period. It stretched out to a 26-year period. And towns were forced to file declaratory judgment actions and work their way through the court process instead in the third round to achieve compliance. The third round ends on June 30th, 2025. And knowing that the third round was coming to a conclusion, last year the legislature adopted a 75-page bill known as A4, making widespread amendments to the Fair Housing Act. That bill changed the process. It officially stripped COA of their power and created a different administrative entity to review compliance. But the most important thing that it did was it set forth stringent deadlines for towns to comply with. One of those deadlines is by June 30th, every town in the state of New Jersey has to file a new housing element and fair share plan addressing its fourth round obligation. If a town fails to do so, they will automatically lose immunity on July 1st. Towns did not automatically lose immunity over the past 26 years during the third round. There would have to be a filing in front of a court, hearings, papers exchanged, and a ruling. No one automatically lost immunity. So this is dramatically different. And so the other wrinkle is everyone is being forced to do this by the same deadline, which is making it very difficult because there are only so many professionals in the state of New Jersey who do affordable housing work. So hence the reason we are meeting on a special night to adopt this plan before the deadline. I should also mention that a housing plan is unique in the compendium of master plan documents because it is the only master plan document that requires both approval and adoption by this body, but it also requires endorsement by the governing body because it contemplates expenditures from your Affordable Housing Trust Fund. So after the board's action tonight, assuming you vote in the affirmative, the governing body will take action on this item at their July meeting. So it's a two-step process. For the June deadline, all we need is the planning board to adopt the document. So before I go there, the the immunity part. So why is it important to maintain immunity and file a housing plan by this deadline? The amendments to the Fair Housing Act carried forward the carrot and stick approach that had been employed by COA in the first and the second round and by the courts in the third round. And the carrot has been that if towns voluntarily come in and comply with their affordable housing obligation, they will be given immunity. If towns do not follow the statute and voluntarily comply, they will be subject to a builder remedy lawsuit because they do not have immunity. Well, what is a builder remedy lawsuit? Under a builder remedy lawsuit, a developer, typically, or a property owner, or a contract purchaser of a property can file a builder remedy lawsuit with the county level housing judge for your region. And they will go to that judge and say, Judge, Town X is not complying with their constitutional obligation, but I, nice developer, am going to build 500 units on this 1 acre piece of property to help them with their affordable housing obligation. And the judge would hear the merits of the case. And if the judge agreed that the town was not acting in good faith, did not have immunity, he would issue a remedy. The remedy does not take into account your master plan. It ignores your zoning ordinance. It removes this board of its powers of reviewing that site plan application. It is blind to whether or not your schools have sufficient capacity for children or whether you have sufficient police officers to police that new development. In summary, a builder's remedy lawsuit, if won by that builder, the town loses all control. And that is why it is so important to maintain our immunity and meet this June 30th deadline. So with that background, I would turn our attention now to the housing element and fair share plan. If you have a copy, that's great. If not, I believe it's going to be on the screen. The process...
I'm sorry, Mr. Chowdhury. Yes, please.
There's most certainly a deadline. If we do not adopt the plan tonight, we would either have to carry the meeting to another date between now and June 30th, or if we do not submit a plan by June 30th, we will automatically lose immunity on July 1st.
What I would suggest in that eventuality is, obviously the plan has to be adopted. But it's not unprecedented for amended plans to be adopted. So if there's, it could be revisited, in July or, December or 27th. Whenever, you could always revisit it.
Sadly, though, and I don't want to interrupt you from your comments, we do have a sword hanging over our neck here, as does every one of the other 560 municipalities of New Jersey. We've put together, well, I'll let you comment on this, but, I believe we've put together the best plan in a very bad situation. Obviously, we'll all have to come to that or a different conclusion tonight. We were given very little time, and now we're out of time. We were given almost no time, candidly. But I'll reserve my comments for later. But we got a sword hanging over our neck here, and is somebody going to run to the courthouse on July 2nd or 3rd or 4th or 5th and start to try to build things here? I don't know. Maybe. I don't know how much of a risk that is. And if we then take action later than that, do you put the genie back in the bottle? I don't know. But unfortunately, obviously everyone's gonna have to come to their own decision, but, it's very likely this is what it is. And it's it's an exceptionally bad process. And if it sounds like it doesn't make sense and it's unfair, it's because it is.
Thank you, Councilman. Just a piece of administration. Mr. Simone, I'd like the record to reflect the presence of Mr. Mike Pappas. Thank you.
So I do think it is important to note that this housing element and fair share plan before you, we did not start working on this last month. We didn't even start working on this last year. We actually started meeting and discussing the fourth round before they amended the Fair Housing Act. We started back in December of 2023, looking at what we would be needing to do, and we actually put out a target number that we were working towards before we even had our number from DCA. So this process has been ongoing. This was not done while the deadlines have been short and abbreviated. This has been something that I've been working with the administration and all of the township professionals on for over a year to come to this document. And what I think folks will realize from a review of this housing element and fair share plan is that Bridgewater's proactive efforts have allowed the township to meet its affordable housing obligation in a manner that fits within the existing scale and development pattern of the community. So with that, let's turn to the housing element and fair share plan. The first page that I would call your attention to, I went too far, is page 4. And I'll zoom in because this is a little bit like an eye exam sometimes. So the key question everyone wants to know when you bring up a housing plan is, well, what's our obligation? And so every town in the state of New Jersey, except for urban aid communities, has a 4-part obligation. The first component of our obligation is rehabilitation. These are units that are occupied by low and moderate income households that are in need of repair. They are not deed-restricted affordable units. Our obligation for rehabilitation is 130. Next, we have the prior round obligation. This comprises COA's first and second rounds of affordable housing. Our number for the prior round is 713. Then we have the third round, which is the 26-year period round. That obligation is 1,414. That number was also established during the third round. The new number is the fourth round number for the 10-year period commencing on July 1st, 2025. That will run then until 2035. You see in the table that that number is 421, but that is not where we started. Last fall, DCA issued the township an obligation of 474. Eventually, after that issuance, we received the backup documentation to show how they arrived at that number. And what we quickly learned is that their land capacity analysis was flawed. They included in the land capacity analysis as vacant and developable the median of Route 22. A portion of properties that are developed, so the front and side and rear yards that had woods on existing houses of worship were considered as vacant and developable. Some of your property on your ROSI, your recreation and open space inventory, was included as vacant and developable. So ultimately, we presented that data to the court, and the court agreed with the information that we presented, and our number was adjusted downward from 474 to 421. So that is an 11.2% decrease of our number by doing our due diligence. So those are the 4 numbers that we have to satisfy in this document. As you page through the report, specifically Chapter 2 on page 7, you will see a list of items. Underneath the municipal land use law, there is a list of all the components that a housing element and a fair share plan have to include. This list is copy, cut, and paste from that document, and the housing plan in front of you contains all of those required elements. Following that, Chapters 3, 4, and 5 include demographic data. All of this information is mandated by the municipal land use law. You may find it interesting, but I will tell you that that data does not affect our obligations, nor does it impact our mechanisms. If you page ahead to page 24, Chapter 6 is a projection of housing stock. We're required, under the statute, to project for the next 10 years how many housing units we believe that Bridgewater will build. Now that's a bit difficult because we don't know over the next 10 years, will there be a housing recession or will there be a housing boom? But we worked with your construction office to understand what properties already have building permits and are in progress, also what applications have been approved by the board that are likely to be built, and then anything in the future pipeline. And you'll see all of those sites outlined on page 25. On page 26, we're required to say, of those projected units, how many do we estimate will be affordable housing units? And you'll see on page 26, we are projecting that over the next 10 years, Bridgewater will construct 205 affordable housing units. Chapter 7 is a capacity for our fair share. This chapter asks us to analyze what is our land capacity to fit this new obligation, our utility capacity, and what sites are appropriate to locate these housing units. And I think what is extremely interesting is if you look at the maps that are included on the following pages, over 49% of the township is encumbered by, 49% of the township's land area is encumbered by one or more environmental constraints. So almost half of the township has some natural feature that would limit or preclude its development. That restricts or limits our options for where can we locate this new housing requirement. We have a description of our utility capacities on page 28, and also a list of the appropriate locations for affordable housing on page 28. But I'll do a deeper dive into those properties when we get to the second half of the report.
I'm sorry, I need to ask a question here because it's germane. When you say utility capacity, can you define that?
Yes, so water and sewer.
Okay, all right, so presence of water and sewer, correct?
So it's not only presence, but it's also, is there capacity either with where you're sending your sewer to or where you're receiving your water from?
Okay, because the thing, and I'll speak about this later on, that I believe is a substantial threat to Bridgewater and to the surrounding community is that, we support a public utility that includes various piping as well as pumping stations. And then down the line, it goes to SRVSA, to the sewage treatment plant. I have severe concern that when you take Warren, whose stuff goes through our system, as well as Bridgewater's, as well as the various other towns that flow through, I don't believe they've properly accounted for capacity at all. I think our pumping stations are going to be overwhelmed potentially. I think that the SRVSA treatment plant is going to be overwhelmed. And in order to alleviate that, we're talking about millions and millions of dollars of infrastructure investment that's going to need to be made.
You raise a valid concern, and I can tell you that the in-house engineering staff reached out to the sewage authority, and they indicated that the treatment plant currently has capacity for the proposed affordable housing developments that are outlined in this plan.
But
Right, you're conveying.
do they also have capacity for any other private development that occurs? Or if the private development occurs and takes the capacity first, what's the straw that breaks the camel's back, so to speak? Is it going to be these units? Because these may not be the only units that get built over the next 10 years. Subdivisions may occur. Individuals may add on to their homes, add additional toilets and other facilities that are going to feed into the system. So I have some very severe concern that there will be negative downstream consequence, and that there is a limit to the capacity. And while maybe the answer is sure, we can take on these 200 units or these 400 units, okay, but does that get us to a point where maybe not in 2035 we have a disaster, but we're pretty darn close to it? And then those who live in this community are going to be looking at rate increases for their sewers that are going to be astronomical. Because adding on to a sewage treatment plant is not like adding, a sunroom on the back of your house. I mean, when you start adding on or secondary or tertiary sewer treatment plants, you're talking millions, tens of millions of dollars. And so, I know the due diligence was done and the answer is yes. I just question if the answer in time is truly going to be yes.
I think all of your points are valid, Councilman, and what I would recommend is that after this housing plan is adopted, that the township sit down with the sewage authority, because by, in 5 days, all of the towns that send to the sewage authority will have to have their adopted plans, and then we'd have a comprehensive picture at how many total units are proposed in the various towns that send their sewer to the authority, and then they'll have a full picture of what that looks like and can they accommodate it.
Okay, but so what you're saying is utility capacity, at least at the surface, has been asked and answered.
Yes.
Okay, whether that turns out to be accurate and true, time will tell.
All I can tell you is what was reported to me, but this is not a concern that is limited to Bridgewater. I have several towns that, depending on how many of their units get built, may have either a water or a sewer issue. So I do think it warrants a meeting to have that larger global discussion so that everyone has their eyes wide open.
Okay, and I mean, just to brief, I don't want to on this sidebar go on longer. I've been down into the pumping stations. I've taken it as a serious responsibility to understand how this multi-million-dollar system works. We're not an island here. There are homes in a wide range of communities around us who are tied into our piping, and then ultimately into our pump stations, and then ultimately further downstream into the sewer utility, the sewer authority. Michael confirmed this. Warren's is coming through us. Part of Greenbrook is coming through us. Part of Branchburg is coming through us. Others? That's about it. Those are the highlights. So again, we should also be concerned, well, what's Warren's planning board doing? What's Branchburg's planning board doing? What's Greenbrook's planning board doing? Is Greenbrook building on a part of their town that's flowing our way or flowing the other way? Is Branchburg building on the part of their town that flows our way or flowing the other way? This is not a small issue, and it's not a trivial matter. Because one of the commitments that we have here in Bridgewater is, that we are going to properly fund our utility, because, when you flush your toilet, it needs to go away from your house. That is a responsibility that we have, and to provide the infrastructure to make sure that happens, and not, hopefully it'll go down, but maybe it won't. Again, I don't want to get more graphic than that, but, that's what's at stake here. Is because at a certain point, if there is insufficient capacity and insufficient utility, can't guarantee that what you think is going to happen is going to always happen.
Can I add in something that concerns me too? We had a pipe issue, the water main break. Last year? Was that last year? And then an even bigger one a little bit ago. And I run a business in the area, but I also live in the area. And my house lost water, but the business did. And when I talked to New Jersey American Water, they've got piping that's really, really, really old. So from how I understood it. So now we're going to have more usage, more water running through the pipes. Like, yes, can the capacity fit it? Maybe at this point in time, maybe not for the future. But what's that going to do for the old infrastructure? Because they said it's only a matter of time. I mean, I spoke with someone who said it's only a matter of time before more comes with needing to replace many of our water main pipes.
And that'll influence your rates, because again, New Jersey American Water, if they're investing in their infrastructure, they're going to pass that on. So it's interesting, you're worried about the inflow. I'm talking about the outflow. It doesn't really matter, I mean, it's a system that works, not all the time, and these are strains and stressors that eventually could cause substantial financial liability. But okay, I know you have a whole presentation. I don't want to belabor the point.
I'd like the record to reflect that Ms. Sikora is in attendance for comments made. All good.
So, continuing on, so where I would like to focus our attention is chapter 10. Page, if I could see the page number, page 40. So oftentimes when I am presenting in front of planning board or a council, there is a common misconception that affordable households have no income or they are homeless. And that is not 100% accurate. Are there facilities, specifically Section 8, where they do not have to have an income? Yes. But the overwhelming majority of affordable housing that is built in this state is regulated by both an income ceiling and an income floor. So the table I'm showing on the screen are the 2024 regional income limits, which of course were updated after we had to have this on file. But it paints you a really good picture of what kind of incomes are permitted to occupy these housing units. So for your region, there's 6 regions in the state, a single person could make over $81,000 and be considered an affordable housing unit. The income increases as the number of members of your household increases. Conversely, there is also a floor to income. And I'll give you the example from a rental perspective. Under the regulations, an affordable household cannot be rented an apartment if the rent exceeds 33% of their income. And there's a lot of logic in that, because if they're paying 50% of their income in rent, you are setting that household up for failure. How are they going to put food on the table, pay the electric bill, drive a car in a state that you need a car to get around in? And so there's both an income ceiling and an income floor for affordable households. So then we'll turn to the following page, the start of chapter 11. So as I said at the beginning of the presentation, we have a 4-part affordable housing obligation. Beyond the overall obligation, the prior round, the 3rd round, and the 4th round all have micro requirements that we have to meet. And those micro requirements are different depending on which round you are looking at. And so you will see on page 41, there's a table for the 4th round micro requirements, which are calculated completely different than they were calculated in the 3rd round. So there is a minimum % of our units that have to be available for families, which really is it's the wrong term, but that's the way the rules call it. When they use the word families, what it should have been called was non-restricted. Any affordable household can move in. It's not restricted to any population. In addition, a certain % of our units have to be rental units. Then a certain % of our units have to be family rental units. Conversely, the number of age-restricted credits, or for seniors that we can apply, are capped, and the number of bonuses that we can receive are capped as well. So not only do we have to satisfy each one of these obligations, we have to make sure that we check the box for all of these micro requirements when we're putting together this housing plan, which this report does meet all of those micro requirements. So then we turn to page 43, chapter 12. And this, in my opinion, is the heart of every housing element and fair share plan. Because once you know your number, then the question is, how do we meet the number? And so this chapter is divided into 2 sections. The first section focuses on all of the existing mechanisms that are creditworthy as we sit here tonight. The second half of this chapter then analyzes the proposed mechanisms, either that are under construction or in progress or zoned for. So let's start with what I consider the good news. Our prior round obligation. So tonight, as we sit here, we have a total of 807 credits, 143 bonuses, which total 950 credits from 13 mechanisms that completely satisfy our prior round obligation. And if you were paying attention at the beginning, you would go, Darlene, our prior round obligation was only 713. Yes. So that means those prior round mechanisms, all of the proactive planning that went into, was put in place, has paid dividends, because not only have we satisfied that prior round obligation in its entirety, we were able to carry forward those surplus credits above the 713 unit obligation and apply it towards our third round obligation. So then we turn to page 44, 45, and 46, because there are that many existing credits for the third round. So we carried forward 237 surplus credits from the prior round to apply against that 1,414 unit third round obligation. In addition to that, we have over 50 mechanisms that exist on the ground today that range from 100% affordable housing developments, group homes, assisted living facilities, and inclusionary housing developments. And if you turn to page 46, what you'll see is we have a grand total. If I zoom in. I should also mention the extension of controls. So this is something that Bridgewater has been a pro at. Other towns should emulate your efforts, because certain units, when they were built, the for sale units, had the ability for towns to unilaterally extend the controls on those units when their initial deed restriction expired. And Bridgewater has been proactive, and before those deed restrictions toll, they have extended the controls with the stroke of a pen, because you can do that via resolution. And so instead of building hundreds of new units to otherwise generate the same number of credits, we have utilized the existing affordable housing stock in Bridgewater, extended those controls, therefore those households get to remain in those units and reap the benefit of reduced taxes and et cetera. And we gain the benefit of a second credit for all of those units. So as we sit here tonight, we have a total of 1,070 credits, 278 bonuses, which totals 1,348 existing credits to apply against that 1,414 unit third round obligation. That is excellent. Not many towns have that percentage of their third round obligation already completed by this point. So furthermore, we have credits that we can apply to the fourth round that hasn't even started as we sit here tonight. So when the attorneys went back and looked at all the credits that we have previously extended and were part of our third round settlement agreement, what they realized is that there were 158 additional units above and beyond what we claimed credit for in our third round housing element, our housing element and our Fair Share Housing Center settlement agreement that were extended and are credit worthy now towards our fourth round obligation. And you will see each and every one of those addresses, because we wanted to have the proof attached to this document to verify those credits. So you'll see all those addresses on pages 47, 48, 49, 50, 51, and 52. So we have 158 credits before the round even begins, based on just extending those existing controls. In addition, in doing all of our analysis, all this preparation that's been going on for over a year, we learned that there was an existing group home in town with a deed restriction that was not counted as part of our third round settlement agreement. So while there is a plethora of existing group homes that we did receive credit for, this one at 416 Route 28, we did not. So because it is a supportive and special needs housing unit, we get a credit per bedroom as opposed to a credit per unit, and we get a full bonus per bedroom. So what is from the outside a single family home, we receive a total of 6 credits on the ground today. In addition, the planning board approved many years ago, I think it was back in 2017, yes, the Delaney, which is an assisted living facility. It's multi-level care facility. There is a component to it that is licensed as an assisted living facility. And in order to receive a license to operate an assisted living facility in the state of New Jersey, the operator is required to set aside 10% of those assisted living beds as Medicaid beds. Medicaid beds count as low-income units. And so 10% of the assisted living component are 9 credits that we have on the ground today. So looking at page 53 in the center of that page, you will see tonight as we sit here, before the fourth round has even started, Bridgewater has a total of 173 credits to apply against our 421 unit obligation. Once again, all this proactive work leading up to the housing plan is paying dividends because it lessens the number of units we need to build moving forward. So now we turn our attention to what's proposed. So we start with the rehabilitation obligation, which is 130. So the first thing we're going to do is continue what we have been doing for the past 8 plus or minus years, and that is a township-sponsored rehabilitation program. We utilize the Affordable Housing Trust Fund, which is funded through new construction, whether that is a new single-family home or new non-residential development. They have to pay a portion of their equalized assessed value into that Affordable Housing Trust Fund, and then the trust fund can only be used for very specific affordable housing related purposes. So this program is open to existing property owners in Bridgewater. It cannot be a deed restricted affordable housing unit. The household has to be of low or moderate income, and the home must require one or more major structural repairs. So new roof, electrical, insulation, windows, if they're on a well, new well, those types of things. It cannot be used for cosmetic purposes. And we are setting aside $10,000 per unit to renovate up to 30 homes. Based on our experience in the third round, we believe that funding is sufficient. So that is what we're going to do to address our rehabilitation obligation. Now, you may say, Darlene, 30 is not 130. If for some reason we have more than 30 folks approach us and we need to expand that program, we will certainly do it. However, because the program has a lot of restrictions, like you have to record either a lien or a mortgage on the property, many folks are hesitant to enter into the program. So based on my experience in all of my other towns, setting aside funding for 30 will be sufficient to check the box for rehabilitation. The prior round, as I mentioned, has been completely satisfied, so there's nothing further we have to do on that front. The third round, we have 2 proposed strategies. So starting at the bottom of page 54, you will see the first one is Eden Woods. This property is located along East Main Street, County Route 533. It has been zoned under a redevelopment plan for inclusionary housing. In fact, that property was approved by the board back in 2016 for a 220-unit inclusionary development. There is both the property owner has been designated as the redeveloper, and a redevelopment agreement has been designated. So all of the components are in place for that site to develop as an inclusionary development. If the full build-out of 220 units was realized, we would receive a total of 44 credits from that site, as well as 44 bonuses. So Bridgewater has done everything they're required to do under the statute. We have put the zoning in place. We have made the development of affordable housing a realistic development potential. We've entered into a redevelopment agreement, and now we are waiting for the developer to move ahead with their construction or submit a revised plan. Then we have Bridge House on page 57, Bridge House 2. So this property is owned by Somerset Home for temporarily displaced children. Although the applicant that was in front of the board was Visions and Pathways, and they have received approval to construct a 10-unit building for young adults who have aged out of foster care. That facility is considered under the rules a supportive and special needs housing facility. And so we receive for that property 10 credits because of the 10 units and 10 bonuses. So a total of 20 credits from that site. Those 2 mechanisms would then satisfy our remaining third round obligation. When you total up all of the credits between what exists and what is proposed, what you will realize is that we, based on the town's proactive efforts over the past 8 years, will generate 42 surplus credits that can then be applied against our fourth round obligation. In addition, we have a handful of proposed mechanisms. The first one is located at 901 Route 202-206. This is a vacant-owned property that the township owns. In fact, they utilized Affordable Housing Trust funds to purchase the property, so we have to utilize this property for affordable housing in some shape or fashion. The township is partnering with Novell, which is a known affordable housing developer, to construct a group home on that property. The property is located in a single-family residential zone, and group homes are permitted as of right under the municipal land use law in single-family zones. Novell has committed to construct a minimum 4-bedroom group home on that property, and the township has committed some of its Affordable Housing Trust Fund to help with the construction of that site. Once that property is built and the deed restriction is put in place, we will receive 4 credits and 4 bonuses for what is otherwise a single-family home. Next, on page 63, we have another township-owned property located on Whitney Court. This site is vacant today, and the township is partnering with CCC Housing, which is a affordable housing operator and developer. CCC is proposing to construct a 5-unit building in what looks like a single-family home, and that building will be reserved for individuals and their families who are either deaf or hard of hearing. The building will qualify as a supportive special needs housing facility, and because of that, we will receive 5 credits and 5 bonuses for, once again, what looks like a single-family home from the outside. Then on page 64, we have a site located along Cornell Boulevard. You may say, where is that? It's sandwiched between Cornell Boulevard and Route 202-206, but more of a locational factor is it's next to the diner on a wooded tract of property. This site is privately owned. It is oversized for the zone. It's over 1.5 acres. And the township is, once again, partnering with Novell to subdivide that oversized lot into 2 pieces. The larger of the 2 pieces would contain an 11-unit, 100% affordable rental building, and the smaller piece would contain a 4-unit family rental building reserved for disabled veterans and their families. This property would yield, and actually on your screen you'll see a map of the site. It is irregularly shaped, and access would come through Cornell Boulevard, not through the highway.
But you could walk to the diner.
You could. I have to admit, I have a vision in my head of a group of cute retired veterans sitting at the diner having a cup of coffee. So this site, when developed, would generate 15 credits and 15 bonuses, so a total of 30 credits from that site. Next, we move on.
I'm sorry, can I sidebar for just a quick moment, if you'll indulge me? So, Mr. Pappas is our administrator, so, we have a regular and ongoing dialogue about township matters, and we are both in agreement, he as administrator, myself as a councilman, that when we as a community can do things that encourage housing for veterans, disabled, others who have some other limitation, I'll do that all day long, because I think it's good public policy. I think it's morally right to be able to, where possible, provide reasonable housing options. And when this was presented to me, and disabled and veterans, I'll do that. I'll support that all day long. Now, clearly, we can't make a whole town of that, but I think that this portion of the plan and the fact that we will be able to welcome people into our community who have done a service and who have a need potentially related to that service, I think is it's touching, really. There's parts of this plan I don't like. Don't get me wrong, But that's an element, and, you know, Mr. Pappas and I have had conversations about the number of boxes that something like this checks is a very positive story to our community.
Thank you, Council.
So now we're on page 68. And we turn now to, from the 100% developments to the inclusionary developments. Because we have to, remember, we have to meet all those micro requirements, and we do not have an unlimited amount of trust fund money to build out our entire plan based on 100% affordable housing developments. So of course, over the past year, we have received numerous phone calls from many developers and property owners who have asked to be included in our housing element and fair share plan. And we have met with everyone who has asked for a meeting, and we've evaluated all of their proposals. And what you have before you tonight are a series of proposals that check several boxes, and we think fit within the township, and also are a good, what I'll call, bang for your credit buck, because we want to maximize our bonuses when we prepare this housing plan. And so first we have KRE. KRE owns a property located at 520 Route 22 East. The building right now is an office building. It contains, I believe, a credit union. It is immediately next to the Bridgewater Court inclusionary development. And so we met with KRE, and we actually negotiated with them to construct a 128 inclusionary multifamily development, which would contain 28 family rental affordable units. If you do the math, that equates to a 21.87% set aside. That is higher than the normal set aside you would receive on an inclusionary development. And this is one of the reasons why they are in our plan. You'll notice a theme with all of the sites that have been selected. We have worked really hard over the past few months to make sure that where we are building these inclusionary developments, we are getting a higher set aside than one would normally receive to maximize our affordable housing credits and minimize the number of housing units we need to construct overall in the township. So that property would generate 28 credits from the 28 affordable housing units. And because we are doing redevelopment of a commercial property, we get a half bonus per unit. So we get 14 bonus credits from this site. Then we move on to Bridgewater Plaza. This property is located at 250 Route 28, but it actually has frontage on Route 22 as well. So this is closer to the intersection of Route 22 and Milltown Road. The property today is developed with 2 office buildings, and BNE Associates and Sterling Properties approached us with a joint venture, and we negotiated with them, and what we ultimately settled on is a 140-unit multifamily development with 31 affordable housing units. That is a set-aside of 22%. When that site is built, we would receive 31 credits for the affordable housing units and 15.5 bonus credits, because once again, we're redeveloping a commercial site, and we get a half bonus per affordable unit from that property. The next site is at the bottom of...
Excuse me, Ms. Green, could you just clarify what we discussed after we discussed the draft of this about the vehicular access?
Oh, yes, thank you, Mr. Pappas. So the one thing that we will be doing as part of the ordinance for this property that would allow the development is that the site access would be from Route 22, and Route 28 would be limited to emergency vehicle access only. Thank you for pointing that out.
And if you could clarify, where would that emergency access be?
So the on Route 28, so there are driveways today at the office building on both Route 28 and Route 22. What we're proposing as part of the ordinance is that the property access for all the renters would be on Route 22, but there would only be emergency vehicle access to Route 28. So that would not be for the occupants to come in and out of Route 28, only for emergency vehicles. And that would be something that this board would review when they come in for their site plan application to confirm that they are meeting those requirements. So that is the Bridgewater Plaza site. Then we move on to Frontier Road, 1400 Frontier Road. So this site is currently vacant, although I know it was previously forested and then it was clear-cut by the preceding property owners. The township was approached by the current property owners, which is Frontier Developers, and they are seeking to construct an age-restricted inclusionary rental development. Initially, they came in with a number much higher than what is in this plan, but through our negotiations, we have whittled that project down to a total of 340 units with a 22% affordable housing set aside based on credits, not units. And so there's a nuance with this property. So 70 affordable senior apartments would be within that complex. And then to get to the 22% set aside, the developer has committed to have one of the units be a 5-bedroom alternative living arrangement. So with an alternative living arrangement, we get the credit by the bedroom. Combining those two numbers gets the developer to a 22% set aside. So that property would generate 70 credits for the senior affordable units. We would be able to receive 7 bonuses for the age-restricted component, and then we would receive 5 credits for the alternative living facility, and then 5 bonuses for the alternative living facility bedrooms. So if you turn to page 75,
Yes,
I'm
Ms.
sorry, let me just mention one thing on that site. I think it's important to note that this property was previously approved and currently has preliminary and final site plan approval for the construction of 2 4-story hotels, a 757-seat banquet hall, a 357-seat restaurant, and a 10,000-plus square foot adult social center. So the proposed use of 340 senior units will be much less intense than the approval that is currently allowed as we sit here tonight. So I think that's an important distinction. While it is a vacant site, unlike the 2 preceding sites that I discussed that are active office buildings, while this site is vacant, the approved development would generate a whole host of traffic at all sorts of hours because of those, board-approved uses.
I'm sorry, I need to interject only briefly to say a previous planning board with
not this current
none of the members who are sitting on this dais right now, under a very different philosophy about development in Bridgewater, approved that site.
Excellent point.
One other point, if I could, Ms. Green mentioned it was clear-cut. There have been drainage issues associated with that, and when the clear-cut took place and there was a significant problem with runoff on the road, our township engineer then looked at the drainage plan that had been approved as part of this development that was mentioned that had been previously approved, and he believed it would be woefully inadequate if that was developed. So we would have seen a serious drainage issue there for a long time.
So those are all of the proposed mechanisms. So when you turn to page 75, you will see a summary of the proposed sites and their credits. So that rehabilitation program, we have no idea how many individuals are going to come take advantage of it, but we're going to put it in place, and that's all we're obligated to do. If no one knocks on our door to take advantage of the trust fund money, we are not penalized. Then we have the 2 remaining third-round sites, Eden Woods and Bridge House 2, that when built will contribute another 108 total credits to our tally. Because of all the township's hard work over the past decade, we'll have surplus credits from the 3rd round, which totals 42, and then our 6 proposed sites will then generate the remaining credits which will total 265.5 credits. So then turning to the table on the following page, and actually I'll skip over prior round because we've already talked about that. Prior round is satisfied. We don't have to worry about that. Third round, as I mentioned, is almost satisfied except for Eden Woods and Bridge House. They have an asterisk beside them because that means that their proposed mechanisms not yet finalized. As you can see at the bottom of page 77, once those two remaining mechanisms are completed, we will have 1,456 credits to apply against a 1,414 unit third round obligation, which means at the top of page 78, you will see that we have 42 surplus credits from our third round. We have those 158 extensions because of the township's proactive efforts in extending existing units. We have the existing group home, the existing assisted living facility, and then we have the proposed alternative living arrangement group home at 901 Route 202-206, the supportive housing facility on Whitney Court for the deaf and the hard of hearing, the Cornell Boulevard property that will have both the 100% affordable component and the disabled veterans component, and then we have only 3 inclusionary sites. So that totals 438.5 credits, which exceeds our 421 unit obligation. And so I think it's important to note that if we were to instead not have done all the proactive efforts over the last decade and just sit back like some other towns have done and do nothing, in order to build or to generate the 421 affordable housing credits that are required as part of the fourth round, if we did that purely through inclusionary zoning at a 20% set aside, this housing plan will be proposing the construction of 2,105 new homes. The plan in front of you tonight with the proposed mechanisms for the fourth round mechanisms, will only construct 629 new housing units. That is less than 1/3 of the number I just quoted you. So all of this hard work, this proactive planning, thinking ahead, has really paid dividends to the township, because otherwise we would be talking about rezoning many more sites with many more housing units, with many more impacts on our infrastructure, not only our utilities, but our school system and our township staff and our police department. And so, in summary, what you have before you tonight is a plan that leverages our township-owned properties, that strategically has located sites, and has minimized the amount of construction to meet what is an unfunded mandate from the state of New Jersey. I want to thank the administration and all of the township professionals and staff that have helped in coming to this plan. It has been a long journey with a lot of hours and a lot of late nights in front of the council in closed session to figure this document out, but I am really proud to sit here and present this plan tonight because I believe it is a really excellent plan that meets our constitutional obligation and minimizes the impact to the township.
Ms. Green, thank you for that extremely detailed presentation. I think all the board members here, thank you for that presentation. Probably do have a few questions.
That's fine.
If not comments.
Actually, I just need to make a comment before some questions. I know there'll be questions. Just to put into context, Bridgewater right now has roughly 15,000 housing units, plus or minus. So that 2,000, so this will change the face of Bridgewater. There's no question. What's at stake is how much change are you talking about? Mm-hmm. So to go from 15,000 to 15,600, while that's, what, about 4%, to go from 15,000 to 17,000 would be much more than that. And those are the kinds of numbers that certain other towns have seen in order to meet their third round obligation, mm-hmm. and now their fourth round. And I don't want to disparage any other of our surrounding towns, except to say, you drive up and down 22 and you see it. You drive up towards 78 and you see it. Particularly when when you drive west on 22, the township between Bridgewater and the Hunterdon County border. You see it. Some of those communities run the risk of being almost unrecognizable compared to what they were. This plan is a change, and it may not be wholly wanted change. We'll all deliberate and share our points of view, but, with that sword hanging over our neck, with all these obligations, with a lot of uncertainty for certain things, which I'll also go into, not now, but, when we're deliberating. The fact, there was so much preparation, but then ultimately, this has been like a forced sprint for us. We didn't even get our number until January. We had to take action as a council by January 31st or whatever. We scheduled meetings not knowing if there was going to be snow. What happened if there was snow that night? We were going to have to we were probably going to have to get picked up by police vehicles and brought here because we weren't going to have to meet that night. There was no other option. And then it's been this like maniacal sprint. And as you pointed out, and thank you for providing us such outstanding professional support, there are a limited number of people who can even do this work, from planners and attorneys and everything else. It's craziness. It's crazy that these deadlines, thankfully we did all this preparation to be able to even complete this. But, the deadlines, and it's not the way to run a railroad is all I'm going to say. But within the constraints, we'll all deliberate, maybe we'll ask questions first, but, I do want to thank you for educating us, offering us many alternatives. The ones you see here are the ones with the most support among the council members and the administration, and that made the best planning sense.
Mr. Chowdhury, please.
We echo Councilman Carr's. In fact, for the first time I could read it, and to be honest, it was good, and I understood it. That's been worst part of it. Thank you very much. I actually agree with Mr. Carr that it is really a fantastic plan. I still have a question though, for a number-wise. Initially, in the first few pages, you mentioned that you were going to build 205 units somewhere.
In the projections will be a total of 205 affordable housing units.
Okay. And that is a part of the 600 that you mentioned overall?
It is, so that is part of our fourth round obligation and our third round obligation.
So total third round and a fourth round, that 205 units is basically part of the 600 unit that you are...
Part of our overall obligation. So what is confusing is we will always have more credits than units because of the supportive housing properties, because that's where we get a credit per bedroom.
Oh.
So, for example, with the group home at 901, 202, 206, that is one housing unit from a construction point of view, but the township will receive 4 credits and 4 bonuses. So one unit from the world of construction and COs, but 8 credits in the world of affordable housing. It makes it a little confusing.
No. You actually, on a 901 Route 202, that is the case anyway, right? That's 4 plus 4.
Yes.
Actually, you are getting the credit and the bonus.
Correct.
Okay. Okay, second questions. So in Bridgewater, out of the 15,000 household, I'm sure there are several of them who actually falls probably below or at the income level that you, in the table you mentioned, probably, median was about 101,000, lowest one about 30,000 or something like that.
Depends on their number of household members.
Right. So that means, can anybody, as a resident of the Bridgewater, can come to us and say, oh, can you include me on the affordable housing, my house? Is that the mechanism is there, or it's not?
So could we theoretically do that? Yes. But in this current housing market, their house is probably worth much more than it would be if they went into the affordable housing program, because then they're restricted on their resale price.
Okay, understood. So while I was thinking that, like Mr. Kars always think about it, how all the, Schweres and all this planning, how to reduce the number of, even from 600 or not, is there any possibility? That's what I was looking for.
I am sure that if a homeowner approached the governing body or the administration over the next 10 years and wanted to do that, we could utilize our trust fund to enable that. Unfortunately, with the housing market stretched so thin and the property, the prices people are getting for some of these homes are astronomical, they'd be restricting the sales price of their home for 30 years. So it's a very long time to artificially deflate the value of your home.
Okay. Well, I was thinking sometimes people, unfortunately, people get divorced and something, and then always go for all this buy house for cash. Those companies really cheat very well, and so I'm sure township at least will be matching those kind of values. For example, if house is $600,000, I'm just picking a number here. If by force, if you want to sell it, probably that may not get that money, but if you have to go to the cash value money, that probably they will not give more than $400,000 or something like that. It's a desperate situation wise. So anyhow, you answered my question. Thank you very much. Now I understand what is. Okay. Thank you, Chairman.
Thank you. Does the board have any questions regarding the testimony you just heard?
I have just a couple questions. I don't want to monopolize too much time, but it is important that we all understand what this is and what its impacts are. So this planning board recently permitted, what is it, 1200 Route 22, a property whose primary likely use is a data center, which would generate no housing units. There is an alternative use that was granted, which would be 200 senior housing units with a 20% set aside. So theoretically, the data center may fail. We certainly hope not, because that was our intention, for it to be a data center. But it might not be. It might be 200 senior units with a 40% set aside. So we're going to pass this plan tonight. Circumstances beyond our control might create 40 senior affordable units. Yet we're still tied to this number. So we don't get to lop 40 off the bottom if something like that happens. We would essentially, due to circumstances beyond our control and situations unknown, we could end up with 40 more units than what's proposed here, and we have no ability to scale back. Is that correct?
So it all depends on when that happens. So if that happens after the program certifies our housing element and fair share plan, we would not be able to scale back. If that occurred before our plan were certified, depending on how far we are in the process, we may be able to amend the plan. So unfortunately, it will all boil down to the timing. And I don't know if that application has a time window to it. Is there a trigger?
I don't know that detail. All right, the second question is, or first a comment, then a question. There is legislation bouncing around Trenton, and usually the worse the idea is, the more likely it is to be passed at some point. There is legislation bouncing around that would permit those who own office buildings, if those office buildings are deemed insufficiently rented or populated, to essentially automatically permit those properties to be turned into residential use. And I guess then all kinds of triggers would occur with affordable, requirements and all. It's not, this is not known, it's just an idea. But, in all of our experience, the worse the idea, the more likely it's probably going to happen. So Bridgewater, obviously has a sizable number of office buildings. It's part of our diversity of our land base, of our land use and rateable base. One of the first thoughts that I had when I heard about that dreadful idea was, is it possible that these office buildings that we have could ultimately become an albatross to us? And do we want to proactively take some of them, especially those that might not be as financially viable right now, do we want to voluntarily take those offline? And that's one of the reasons why you see 2 office buildings on this list, is because what would happen if, we adopt the plan, we didn't include those 2 office buildings, X number of years from now, this brilliant idea surfaces from Trenton as a law, not as an idea. And now all of a sudden we have a whole bunch of these office buildings raising the white flag and saying, I can't make it as an office building anymore. Now I'm going to make it as housing, and I'm going to do a 20% set aside and all this other, all this kind of stuff. Now we're looking at the type of explosive growth that we're trying to prevent. So I guess, I don't know how much of a question this is, but are you, and I don't know your answer, that yes, there is a proposal, its fate is unknown, maybe it'll see the light of day, maybe it won't. So, I guess let me put it in the form of a question. At some point, if something like that were to occur, is having surplus office space a liability for a town?
That bill terrifies me because it undermines home rule, it violates your master plan, and it ignores your zoning ordinance. If that bill becomes reality, those office parks, or I shouldn't say office parks, those office developments are now, you and every other town that also has a sizable office component, is your #1 threat. And so I would encourage the governing body to stay abreast of that bill. I know that they were revising it. It also, at one point in time, did include retail over a certain size. So struggling retail centers would also have the same opportunity to redevelop under one of the versions of the bill. So I would encourage the governing body to stay on top of that, certainly write to your local legislators, because there honestly is no point in adopting a housing plan if that bill is adopted, because you lose all control with that bill.
Well, we lose some control under this. We'd lose all control under that.
Correct.
What bill is that called again?
They had called it the Stranded Assets Bill. I don't remember what its number is.
The Bridgewater Council did adopt a resolution taking a position on that a month or 2 ago.
But the moral of the story is, one of the reasons why among other reasons why 2 office buildings are on here is they are arguably distressed. And essentially, as a defensive maneuver, taking them off the roll, so to speak, prevents something worse from occurring.
Correct. This was a strategic move.
Any other questions, Councilman?
I don't.
Very good. Pepper from this side of the dais here.
Well, I read the report and went around Bridgewater and looked at some of the properties, and I said, yeah, this is a good place where they could redevelop it. And then some places I was thinking, we're scratching for this property. I mean, if we have to use this property, we're really scratching at the bottom of the barrel. I can't help but think on some of the properties and some of the contractors who have come and approached.
Excuse me, Mr. McGuire. Are these questions or are these comments, Mr. Chairman?
Comments.
Okay. Oh, if we're going to take questions, because we have to have the public hearing, so I think shouldn't the board members reserve their comments until later?
Yes, Mr. Pappas, thanks for clarifying that. We're strictly focusing on questions regarding to the presentation just given this time.
We'll hold on then.
We'll revisit that, thank you. Any questions?
Actually, I have a question. This is just curiosity, and I don't know if you'll know the answer to this. So, you know, we've been very diligent. Working with you has been very enjoyable, even though the topic itself is not. Are there towns that are just like, they're not going to make this deadline? They're, you know, like they're not having this meeting a handful of days before June 30th? I mean, are there like horror stories going on right now? Not among your clients, I'm sure, but you know, like is there like panic in the streets, so to speak, in some communities because they're just not nearly as advanced as we are?
I will give you 3 scenarios. I am aware of one town that is located within the Highlands region that will not be preparing a housing plan by June 30th. Now, there's a whole different set of circumstances when you're in the Highlands region because your development potential is precluded because of the Highlands Regional Master Plan. I'm also aware of another town where the planning board adopted the housing plan, but when it was sent to the governing body, they declined to endorse it. And there is one other town that I'm aware of where they have now went through 3 hours of public comments, exhausted the clock, and carried their special planning board hearing to tomorrow night, hoping to get through the packed meeting room full of crowd commenters. So it really depends on where you're at in the state.
We're in a pretty good place.
You are.
It's a great question.
Can you clarify if some of these haven't come through the board, or they haven't come through the board yet to approve them? What happens if a town, you know, we talked about, what is it, yes. What happens if we don't approve of their plan?
Oh, their site plan application?
Yes.
So you'd have to have an awfully good reason for denial. So if they came in with double the density, that's of course a fine reason for denial. In fact, they wouldn't be here, they'd be visiting the zoning board in that instance. So if they were seeking some sort of D variance, then that is certainly grounds for denial, because this has been discussed with these developers that have made it into the plan extensively. So they are well aware of the number of units and the set-aside that is being placed into this plan. If they came in, for example, for a front yard setback and the deviation was 1 foot, I would strongly discourage the board from denying them over a 1 foot variance. So it would really depend on what the deviation is or deviations are and the degree of the deviation. And so it's really a case-by-case issue.
And what if they came, one of the developers came with their site plan and said they wanted to do something completely different? Are they held to this plan?
We will be putting the ordinances in place, and if they come into the zoning board wanting double the density, then the zoning board is within full rights to deny them because it exceeds what we have discussed and agreed upon. You'll notice in the voluminous appendix that we have commitment letters, and there was a very specific reason to obtain those commitment letters in which each one of those developers has listed the total number of units and the set-aside, which comports with what is in the housing plan. So no one can, well, I guess they could claim amnesia, but we're going to have a letter refreshing their memory in case they forget.
They couldn't, in theory, sell and then be held to, like, that property, and then that next person, they didn't write the letter, right? And they're not held to it for a new site plan, you know what I mean?
Oh, so you're saying if one of the current property owners sold, the new property owner would be subject to the zoning regulations that we put in place?
Okay. But also subject to the plan that we put in place for affordable housing?
Correct. So if they wanted to do an alternative use, they'd be once again visiting your zoning board, and they'd have a difficult road to hoe unless there was some, dramatic economical shift that was, beyond the control of Bridgewater.
Got it.
Thank you, Mr. Cora. And Ms. Green, just to clarify and help the board understand, what we're hearing this evening is essentially the plan for the zoning, as I said, as you mentioned previously, to enable that future construction. So what we're hearing this evening really is to approve the theoretical zoning of what would take place under this plan. Is that correct? And essentially, every other case would stand on its own merit when it came before this board.
So you're approving the vision document. The drafts of the zoning ordinances are attached to it. Under the statute, we do not have to adopt the zoning ordinances until March of 2026. So they'll go through the customary approval process. Council will introduce, they'll refer them here for master plan consistency, and then council will perform second reading. So that process will still take place. It's just going to be at a later date because of the way the statute was written. Does that answer the full?
It perfectly clarifies that question for me, yes, thank you.
Mm-hmm.
Are there any other questions from the dais? Are there any questions from our members of the public? Good evening, please state your name and full address for the record.
Mary Gallagher, live in 102 Highland Avenue. Thank you for a very interesting, you helped me clarify affordable housing because I'm very unknown to that. But I do have some concerns because I grew up here. I'm a native Bridgewater when it was all farmland and woods and beautiful. Now we're asphalt and mortar, but the concern I'm having is when I'm hearing a lot of building in your areas and stuff. And the thing that I am concerned with is, as some of you might know, I'm really concerned about my groundwater because I have wells, and there's been a lot of development, and there's been some pollution and contamination of that. So I would like to know when this, it sounds like it's going to get passed, but it sounds like I'm concerned as if there's development in these areas, do they still have to follow the codes like the DEP, if there's a wetland or a floodplain, or if it's a drainage basin? I want to make sure that the areas aren't built in areas that, or could even be risky for the people in that area, where they, if it floods, then they've got to be rescued or something along those lines, or and a hazard. So I just want to make sure that whatever is developed is a safe place to be developed. I mean, I'm on Highland Avenue, and we've never had floods before because we had open drainage ditches when I was growing up, so it never flooded. But there were 2 big floods by the end of my road between 202 and Highland, the intersection, and just flooded out when we had the torrential rainstorm. So that has never happened before. So I'm seeing more flooding. We've had more development, trees have been knocked down, and bigger houses are built. There's less absorption into the waters, and it floods. So I want to be sure that with all this development, with the affordable housing, I think it's all a great idea, by the way. It sounds nice. But I want to be sure it's done safely. That's a big concern. And I want our water supply to be protected, both the groundwater and the city water. Most of Greenall is on groundwater, so it's important to keep that supplied. And we need absorption into the ground to do it. So I just want to make sure that when we're building all these, it's done right. So I guess what I want to know is, will the DEP be involved with some of this? Will there be geological things? Will there be sinkholes? Will there be flooding? Will there be this? Will there be that? What's going to be the right thing to build there? That's smart development, what I'm looking for. So can you clarify, is that true? Will we still have some control over?
Yeah, they're not exempt from environmental regulations or anything like that.
Okay.
And correct me if I'm wrong, Darlene, but really the only thing, you can't put what are called like unnecessary cost-generating features on, so you can't require that like a subdivision, affordable development have, I don't know, gold-plated features or something, as a means to keep it from being built. But they're certainly not exempt from,
lots of,
environmental regulations and stormwater regulations, and, you know, same thing.
yet they don't have to always follow the zoning, or the zoning can be changed. And that sometimes, to me, that change sometimes gets done and it's not right to do it. So I just want to make sure.
But again, they'd still be subject, though, to the stormwater regs.
Okay.
So I apologize that I stepped out. I didn't hear everything you said, but I think I picked up the gist of it.
Wasn't close enough?
I'm sorry?
I'm not using.
No, well, no, because I stepped out for a moment.
Oh, okay.
But
I was just asking.
you're spot on in the question in the questions you're asking. And while the DEP protections will be in place, and you know all attempts by this planning board, once we see site plans, to make sure that whatever is built with as little impact on neighbors and the rest of the community. That's what we've always done. That's what we will continue to do. But you talked about zoning change. Essentially, this is zoning change right here on these various properties. But what has been one of my deepest frustrations is just last summer, we had to adopt a sizable number of what I believe to be unfunded state mandates related to stormwater. So we have the DEP pointing their right finger at us and saying, you town have to do this, 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 and the other thing. And now we've got COA, or whatever this thing is, with their left hand pointing at us, you got to do this, 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 and this. And those two, I'm not saying that they're polar opposites, but there is no coordination. There is no coordination. So, if you think, well, what are the impacts of overdevelopment? There's less place for water to go, there's more traffic, there's lower quality of life and all those things. So while on a property by property basis, we will do the best that we can, and the DEP presumably will enforce its regulation, these are competing mandates that we're getting here. So it sounds like Trenton's talking out of both sides of their mouth on this one. It's because they are. And so within the governor's administration, you've got your head of DEP who's marching in one direction, which may or may not be right. And you've got whoever's associated with this marching in a different direction that may or may not be right. And we're the ones who are squeezed and caught in the middle. Because we're the ones who bought into this community or communities like this because we expected a certain quality of life. And obviously change occurs. And unless you want to buy up all the properties around you, something else could come. But you've asked exactly the questions that mayor and council, administration, we're thinking the same thing. And ultimately, will there be protections? Yes. Will there be as much protections as if none of this stuff ever got built? Unfortunately, probably not.
It's really the water protections I'm really, really concerned about a lot, because I think as we have more droughts and hotter summers, we may see less water, and if we don't contain it, and groundwater is like a savings account, it's there when the aquifers need them and when the reservoirs go dry. So I really just want to make sure that when all this is being developed, that we remember we still need water. You can have all the housing you want, but food, clothing, and shelter is always needed, so.
Ms. Gallagher, I share your concern with the groundwater. I don't live too far from you in that area, and I rely on my well at home, myself, my wife, and my kids. And we want to make sure that they're safe in the protection of that groundwater and the aquifers.
The other thing is that we've had more floods, but it just drains out, and it isn't absorbed anymore. And according to, I get the drought monitor every month now, so, and they're saying that the reservoirs are doing great, but the groundwater is still low. So we need to have more absorbed, and we've been building on wetlands. Bridgewater's been, the mall was built on wetlands. And I think we need to start realizing we need to keep our wetlands so that we have water.
Thank you, Ms. Gallagher.
That's right.
And thank you for your interest in this topic, because this is arguably the most important issue to face this community.
like the idea of the development, but I'm concerned about the number. The other thing would be the traffic. How are these people going to get to and from where they're staying? Are they gonna have cars? Getting enough parking? You know, there's just a lot of attachments to it, but I thought you did a really nice job. And I'm not used to it. But thank you. That's what I.
Thank you.
Another question? Okay. I'm not seeing any other members of the public out there, and that'll close the public questioning for this plan. Are there any comments from the dais?
I want to thank Darlene Green, she and Catherine Sarmad, Bill Savo, Alex Fisher, have been absolutely invaluable in bringing us to this point. I would like to also give credit to Scarlett Doyle because the December 23rd, December 2023 timeframe that Ms. Green mentioned was when Scarlett was still our planner and Darlene was coming in as the affordable housing planner, and we had established a series of meetings for Scarlett to meet with Darlene, Scarlett to meet with Catherine, and then this legislation was signed into law. And the trajectory of these meetings took a different course. But Darlene has really done an outstanding job. The time and the detail that she kind of glossed over tonight is she minimized what she did to locate these credits that we didn't know existed, that were all a significant contributing factor to the report that you have before you. I want to emphasize the point that she made about what 629 units versus what 2,000 was the number again?
2,105.
Yeah, that is a very, very significant accomplishment that this report summarized. And I appreciate Ms. Gallagher's commentary about zoning and how this is, as Councilman Kirsch, you pointed out, two what I think are competing positions that the state legislature ultimately has, either through their action or inaction, has foisted upon the communities in New Jersey. And Ms. Green, I also want to thank you in the first portion of your report, how you summarized pretty concisely very lengthy history of affordable housing program in New Jersey and Bridgewater Township's part in that. It was, if someone needed a history lesson on those two topics, this report really captures all of it. And for those members of the public who may be concerned, as Ms. Gallagher was, reading that and understanding what happened back in the 1970s and how, because of legislative inaction and the courts taking action, that is why we are here. Municipalities are not here through their own choice. This is something that has been mandated. I can't emphasize that enough. But at the same time, Bridgewater has been responsible and recognizing that unless the legislature in the future changes course, this is the reality. And if we did not follow the steps that we've been following, it would be to our own peril, as we are seeing in so many other communities around the state. So I, again, want to thank you very much for your diligence and your thoroughness. I am extremely confident that if anyone would try to question this or challenge this in any way, I believe because of your efforts and our legal team, we are in a very, very strong position. And I certainly would support this.
Mr. Chowdhury. Any other comments? Mr. Magora.
Your report was excellent and well thought out, well put together, readable. And when I toured some of the areas, I could look at your report and look at the areas and say, hey, this helps me understand what's going on. I would hate to be a member of the planning board in 2035 when the fifth pass comes through, because we're running out of property in Bridgewater. And I wonder what other older towns, although Bridgewater is 300 years old or something, how they are handling it. But I'm very pleased with the report, although, as Mr. Kirsch says, you know, we have a, I don't want to say a gun to our head, but certainly a club. And it is what it is.
Ms. Sikora.
I just want to say thank you. I know I came in late, so I apologize. You made some of this sound very simple, which is great, because it is. I mean, I read the report when it came out, and I appreciate, because it put a lot of things into perspective that I didn't, that was very confusing before. So I appreciate that. I also appreciate some of the ideas of doing there's some larger, some lower, some part of the community, so that it's not so right where you can drive down 22 and see it all. And I appreciate that.
Mr. Wang?
Yeah, I'm very happy to learn this report, and thank you so much for the very thoughtful, all the work behind. It's not easy, and the state give us I think give every town some extra burden to me. I think I heard a lot of residents worried about this, and tonight I think that all the plan here, all the sites here, and is the best utilization and the best to our master plan. So that's why I will support this for sure. Thank you. Thank you.
Councilman Kirsch.
Well, since the hour is late, I'll give the short version of this. First, with sufficient respect to Ms. Green and to Ms. Sarmad and to Mr. Fisher and the others, our staff, the fact that we're here and having this conversation is an abomination. New Jersey is supposed to be a home rule state. We are not. Mandates that come from the state are supposed to be paid by the state. They are not. People often ask, well, why are my taxes so high in fill in the blank for whatever town you're in? But we'll answer that for Bridgewater. Why are my taxes so high? Well, gee, I don't know. We've been spending years on this matter, on our dime, an unfunded mandate that is diminishing our right to home rule. So while I will support the plan, because I think overall it is an excellent plan, I just don't, I fundamentally do not believe that this should be necessary. It should not be necessary because Bridgewater already is a socioeconomically diverse community. You can buy homes in this community for a few $100,000. You can rent apartments that exist today at a relatively affordable rate. You can also buy multi-million-dollar homes and everything in between. We already have, by design and by just the natural evolution, we already have diverse housing options. We are not an exclusive community. You can, if you want to live here, you can buy or rent a place right now. We do not need more regulation and less self-control. We have already taken the steps necessary to build a community that we can all be proud to live in. Now, with that said, I will support the plan. I'll even bite the bullet and I'll be the one that moves the plan. All right? But it's not a perfect plan by any stretch of the imagination. I don't think it can be. There are some properties on here that I'd rather were not. There were some properties under consideration that I would prefer be on instead. But in the interest of collaboration and cooperation, I believe this is the best plan that will serve this community until the rules change again. And that's something that also is of great concern to me. When are the goalposts going to move again? When potentially is something that we thought was going to be A is going to become B, is going to now have housing? When is this dreadful idea about the office buildings going to become law? More and more regulation, less and less control of the community we live in, more government control, more speaking out of both sides of their mouth from Trenton. The environmental regulation is absolutely at odds with this housing requirement. I've expressed great concern about the sewer utility. I don't have to go through that again. One of my colleagues on the township council has expressed concern about at what point does development like this push us over the edge to needing at least a partially paid fire department. And if you think your taxes are high now with volunteers, you wait until you see a partially paid fire department. Another of my colleagues has expressed concerns about the schools, the impact on the schools. And I know we've just done a school expansion, but we did a school expansion and reconfiguration without being concerned about this. And I guess what it comes down to for me is this. If you're concerned, if the state of New Jersey is concerned about providing people with places to live, where there is school capacity, where there is sewer capacity, access to water, access to services, walkability to supermarkets, we have those. They're called cities. There is an attempt to essentially urbanize every corner of the state of New Jersey. And that, I believe, is ultimately setting people up for disappointment and potentially failure, because we do not have mass transit. Generally speaking, very few homes are accessible to a supermarket easily. One of these does happen to be foot traffic away from a supermarket, but that's just by happenstance. One of them is foot traffic to the diner, but I don't think you could take all your meals at the diner. But generally speaking, this is a car-dependent community. Those who come into these units, whether they're affordable rate or affordable units or market rate, you're going to need a car. You're going to need a reliable car, maybe two cars, depending upon what your family looks like. So, I believe a plan like this has great risk. It might sound like a great idea, but then ultimately it may not suit what we are trying to do. And ultimately, I keep coming back to the idea that if we want to set people up for success and give them access to jobs and access to supermarkets, access to classrooms that already exist because urban populations are shrinking, sewer utility, all these things, they already exist without forcing us to make them exist. So, that's the short version. I want to thank you again for your time, not just tonight, obviously, but throughout, many, many months and years. Your help guiding us. And again, it's not perfect, but I think it's as best we can hope for. And as was pointed out, though, I don't know what this planning board's going to do in 10 years, because fewer and fewer viable properties exist. But we'll see what the future holds. Thank you.
Ms. Green, arriving to the conclusions presented this evening clearly doesn't happen by chance. I appreciate the tremendous efforts, the months, days, and the hours by you and the team. It's not exactly easy undertaking, especially when you're given the time constraints that Trenton has given you. You made a compelling argument, that you put us in a better position especially with the surplus credits, and Councilman Kirsch brought up several questions this evening that you effectively answered, and I appreciate that. For 17 years, I lived right off of exit 40 from 78. And I can only imagine today, if I were still living there, what I would feel, especially with that knee-jerk reaction type of development going on. And it's just, unfortunately, it's going to have a change, as the councilman brought up earlier. It will change, but I don't believe it's going to be a radical change. It won't be an unexpected change. And I think I need to give credit to where credit's due as well. Our previous planner and that administration or that staff have done, they've clearly put the rungs in the ladder for the future generations. And makes me proud, certainly, that's the type of work that's going on here in Bridgewater. And for that reason, I also will approve this. Mr. Chowdhury.
Everybody else could not do it except you do it. Well, we're going to basically distribute, air hopping plan to everybody else. Or basically, they will also give us some extra burden because other people could not make it.
They've already redistributed the allocation from the urban aid areas to the suburban areas. So in this rule set, they've continued what they had done under COA's jurisdiction. So the DCA's numbers issued almost 85,000 affordable housing units for the entire state of New Jersey. That 85,000 is accumulated from every town in the state. But then the 85,000 affordable housing units are only allocated back out to non-urban aid communities. So places like Bridgewater and other suburban areas are building the units that the urban aid communities have generated in this calculation.
And at the end of the day, we allegedly are a home rule state. But until we're not. and you look at the and then you put on top of that the unfunded mandate, and then so our community is going to grow, not by a lot but by some, and there are formulas associated with that. How many police officers do you need to safely maintain your community, and how potentially are we now going to need more DPW equipment? Maybe. The county is now let's look at the county level. The county is now going to have more recycling bins that they have to process every 2 weeks. Where does that come from? The future is scary. It really is. And I think that since we're looking at, again, what is it, about 600 potential total units off of the 15,000, yeah, it's a change. If we had a number that was the 2,000 or whatever, or some of our surrounding communities that are looking at on a percentage basis much larger, yeah, they're looking at big problems. They're looking at serious questions about how they are going to continue to deliver the services. But I guess that's why we have elections.
Thank you, Mr. Chair. Are there any other deliberative comments?
No. I mean, I don't know if we need to get guidance from Mr. Peck on the action to take, or if it's inherently so obvious that I could just make my motion.
No, well, there's going to actually be two votes. There'll be a vote to, adopt the plan, but then there's going to be a second vote to adopt the resolution.
All right, well,
We want to make sure we have the proper iteration up here, because the version that I have of the resolution was the earlier draft, so.
okay, well then
But I'll work that out with Maria.
Okay.
After and get her to make sure she's.
All right, so I believe it's in order then for me to make a motion to adopt the fourth round housing element and fair share plan of the township's master plan as presented to us by our professional staff. So I make that motion.
I'll need a second.
I'll second.
That's Ms. Sikora. Could I please have a roll call?
Mr. Pappas?
Yes.
Mr. Wang?
Yes.
Mr. Magora?
Yes.
Councilman Kirsch?
Yes.
Ms. Sikora?
Yes.
Mr. Chowdhury? And Chairman Vesio.
Yes. Mr. Peck, at this point, after ironing out the resolution that is to be amended.
Well, yeah, you can, someone can make a motion to adopt.
Perfect.
Yeah, do we, just so that there's absolute clarity, would we want to even just read it into the record, even though, no?
One thing I would point out, I think it has to be signed by either the secretary of the board or assistant secretary, and neither is here tonight. Can we make a?
Have, actually, the board, maybe perhaps before you arrive, have an acting secretary.
Good, very good, thank you.
So then how is the resolution different than what we see in front of us?
There's not, there's just, in the fourth whereas, there's a placeholder that says insert name of municipality. The subsequent version that I sent out says Bridgewater Township. That's it, it's nothing substantive, it's just editing.
Okay, then I will make the motion to adopt the resolution, notating that in the whereas fourth clause, we are speaking of the Township of Bridgewater, and that Mr. Magora will be authorized to take action as our Assistant Secretary tonight.
Thank you, Councilman, and I'll take a second motion. That's Mr. Chowdhury. Could I please have a roll call?
Mr. Pappas?
Yes.
Mr. Wang?
Yes.
Mr. Magora?
Yes.
Councilman Kirsch?
Yes.
Ms. Sikora?
Yes.
Mr. Chowdhury? And Chairman Vesio.
Yes. Ms. Green, thank you very much. Once again, I don't need to re-echo or reestablish anything that's been said here tonight, but this was very educational for the entire board, very detailed, thorough, a lot of great questions and a lot of very proficient answers. Thank you very much.
Thank you.
And best of luck.
I think you've given that presentation before.
A couple times.
Very smooth.
And we'll echo the public commentary before. This is probably one of the better presentations that we've heard under this planning board, so thank you again. Okay, we don't have any other business this evening, so at that point, I'll take a motion for adjournment of this meeting.
Do we have a meeting on next Tuesday? Yeah.
I don't believe so.
No, I was going to mention that we don't have any applications on the schedule, so,
What about, is it looking like for the 15th?
no, nothing on the 15th either.
We have to provide you with the sheet that they handed out last meeting.
Okay. Katie might add.
We may not want to cancel the 15th just yet. Just never know what might come up.
Okay, so I'll send out a cancellation for the July 1st meeting.
Take a motion to adjourn.
I'll make the motion.
That's Ms. Sikora in a second.
I'll second.
That's Councilman Kirsch, all in favor.
Aye.
Aye.
Thank you.
9:05.
Thank you, guys.
Thank you.